A major development for a South Carolina teacher accused of sexually abusing a teenager. And this could upend the case. We're breaking down the allegations against Nicole Callahan, the criminal charges she faces, and what this latest twist means with a unique insight from a South Carolina criminal defense attorney. Welcome to Sidebar, presented by Law&Crime. I'm Elizabeth Millner, in for Jesse Weber. The South Carolina State Board of Education has officially suspended the teaching license of former Anderson County teacher Nicole Callahan. This comes after claims she sexually abused a teenage boy. Officials say the move is necessary because of the, quote, serious nature of the allegations and the potential threat to the health, safety, and welfare of students. Authorities say Callahan, who was a kindergarten teacher and local musical theater director, allegedly exploited her position of trust to engage in inappropriate behavior with a young student over several years. We're going to get into what this latest development means, but first, if you're not familiar with this disturbing case, let me walk you through it from the beginning. This is one of those rare cases where you'll get to hear directly from the alleged victim himself, a teen who made the decision to come forward once he turned 18 years old. He told the court and later the public that he refuses to stay silent and wants people to understand what he says really happened to him. We'll get into his words in just a bit, but let's talk about Nicole, a 33-year-old who was living in Anderson, South Carolina. She was married, had a young daughter, and was known in her community as both a teacher and a musical theater director. From the outside looking in, she was a trusted role model for kids. She even had lighthearted videos of herself online, dancing in a classroom talent show, and smiling with students. In 2021, she directed Legally Blonde Jr. the musical at a local children's playhouse. The group marketed itself as a safe, creative space where kids could build up confidence. And that's where police say she met a boy who was just 14 years old at the time. His family signed him up for auditions, and Callahan gave him a part in the show. Flyers for that production are still on the Playhouse's Facebook page, and parents back then were publicly praising Callahan, calling her an inspiration. It seemed like a pretty wholesome theater project, but according to investigators, this is when the grooming began. According to a police report, Anderson County deputies say Callahan started offering to drive the boy to and from rehearsals, something that seemed like a helpful gesture to his busy mom who had other children to care for. Callahan also had a daughter of her own, which made it seem like she was even more trustworthy. Now, over time, police say that she started opening up to the boy's family. She confided in them about her marriage problems and said that she had a strained relationship with both her mom and her sister. The victim's mother later told the court that she thought Callahan needed support and she was willing to be there for her. But behind the scenes, authorities allege that Callahan blurred those boundaries. According to court documents, she slowly built private trust with the boy and then began to sexually abuse him. His mother eventually discovered what was allegedly happening and confronted Callahan, telling her to stay away from her son. But prosecutors say Callahan didn't stop there. Instead, she found new ways to keep contact, changing her social media handles to avoid being blocked and even buying an Xbox so she could continue talking to the teen while he was playing video games. Another disturbing allegation, the victim's mother later told the court that Callahan's own young daughter was sometimes present during these encounters. By the time police got involved, investigators were building multiple cases against her, and she's now facing a whole slew of charges across county lines. The Anderson County Sheriff's Office said its investigation began in May of 2025. Detectives uncovered evidence that the misconduct had started years earlier, in 2021. On July 10th, the Sheriff's Office posted about their investigation into Callahan, writing, quote, Callahan, an Anderson County school teacher at the time, engaged in grooming behavior toward the boy during his early teenage years. The relationship intensified as she reportedly signed the student out of school, transported him to practices, and served as a supervisor for after-school activities. These repeated interactions led to a prolonged pattern of abuse, which was corroborated by search warrants and ongoing cooperation with the victim's family. According to investigators, the victim made the decision to come forward after turning 18, following time spent processing the experience and trauma associated with the abuse. Based on their findings, the Anderson County Prosecutor's Office charged Callahan with 3 counts of criminal sexual conduct with a minor in the second degree and 1 count of contributing to the delinquency of a minor. Now, under South Carolina law, a person is guilty of criminal sexual conduct with a minor in the second degree if the actor engages in sexual battery with a victim who is at least 14 years of age, but who is less than 16 years of age, and the actor is in a position of familial, custodial, or official authority to coerce the victim to submit or is older than the victim. The punishment for that in South Carolina is up to 20 years in prison. Contributing to the delinquency of a minor, meaning pushing or influencing a child to break rules, is punishable by a fine of up to $3,000, up to 3 years of prison time, or both. Hey, by the way, there's a reason Sidebar is one of the most popular shows on YouTube right now, and just no big deal, but Joe Rogan, we're coming for you. Just like there's a reason Morgan & Morgan is America's largest injury law firm. They're a firm with more than 1,000 attorneys, and that's because they win a lot. They've recovered more than $25 billion for more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. In Pennsylvania, a client was awarded $26 million, 40 times the insurer's $650,000 offer. Another client in Pennsylvania received $29 million after being only offered $500,000. Even if you think your case isn't worth millions, why not start a claim and fight for what you deserve? Morgan & Morgan makes it truly so easy. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on your screen. But gotta point out that Anderson County isn't the only jurisdiction involved here. While pursuing their case, investigators determined that some of the alleged activity occurred in Greenville. A July 10th Facebook post from the Greenville Police Department reads, quote, "During the Anderson County Sheriff's Office investigation, it was determined that some of the alleged criminal activity had occurred within the jurisdiction of the city of Greenville. The investigation revealed that Callahan engaged in an inappropriate and unlawful relationship with a 14-year-old male. Based on evidence collected, Greenville detectives obtained arrest warrants for multiple offenses committed within our jurisdiction. And Greenville County prosecutors charged Callahan with 8 counts of criminal sexual conduct with a minor in the 2nd degree and 4 counts of unlawful conduct toward a child. South Carolina law defines unlawful conduct toward a child as placing the child at an unreasonable risk of harm, causing harm to the child, or abandoning the child. It's punishable by up to 10 years in prison. In May, Callahan resigned from her teaching job. She was arrested after surrendering to authorities on July 10th. She appeared for a hearing in Anderson County where she was released on bond, and following that hearing, the alleged victim in this case, now 18 years old, actually spoke out publicly to the media. His name is Grant Strickland, and here's what he told reporters.
Though it's a traumatic event, I'm here to fight, and I'm not going to back down. And that I think more awareness needs to be brought to things like this, and just because I'm a man doesn't mean that it should be shunned away. Because I was a child, I wasn't a man, I was a boy.
Callahan then appeared in court on July 14th in Greenville County. She dropped a huge bombshell. During the hearing, which you can see there from the court footage per WYFF, she was actually smiling. Then came the big reveal. Her defense attorney told the judge she was 8 to 9 weeks pregnant. He had emphasized that she had pleaded not guilty and would need a surety bond to receive prenatal care while awaiting trial. The court ultimately set bail at $120,000, broken down into $10,000 for each individual charge. I'm joined now by a very special guest to help break all of this down, and that's criminal defense attorney Chris Adams. Chris, thank you so much for joining me today. This is a really, truly shocking story, and what's your reaction to that?
Well, it's alarming for parents who would have schools or students in those districts. We seem to be seeing a lot of these stories nationwide. It seems to be increasing, at least this unscientific view is it seems to be increasing around the country, and it's always scandalous.
And why do you think we're seeing such an increase of these types of cases? Do you think it's because a lot more people feel comfortable reporting this? A lot more people in terms of teachers and other reporting figures are feeling more comfortable reporting this? Why does it feel like we're always seeing these types of cases in what feels like a weekly basis?
My guess is it's all about reporting. My guess is this has gone on forever. And at least when I was a kid, nobody would have viewed a male high school student as a victim. They would have said he was lucky. And Now people are prosecuted when things come to light.
Yeah, and it's interesting too because sometimes I see, under our YouTube comments, some people will still say things along those lines of, "Oh, I wish I had teachers like that," and it's just so inappropriate and disturbing, and it's kind of that stigma that we still see even to this day. And do you think that Nicole Callahan is even taking her case kind of seriously at all? I mean, when she appeared in court last time, she was smiling, she seemed pretty jovial given the allegations that she's facing.
I don't have any reason to think she is not taking the charges seriously. It's the demeanor of someone appearing in court is you can see from the outside, and it's almost there's no proper way for someone to react. If they look like they're carrying the weight of the world on their shoulders, or if they're in tears, supporters of the victims' rights communities will say that's convenient. They're playing a role for bond. If people look more laid back or are trying to maybe put a stronger appearance forward, an appearance of confidence, then they're oftentimes viewed and criticized for being nonchalant or not taking the charges seriously. So it's really hard for any of us to know. She is facing considerable exposure in two different judicial circuits in South Carolina. Is losing her employment. I don't have any reason to think anyone in that situation is going to take this seriously.
And are you surprised that she lost her teaching license at all, especially given that she hasn't been convicted yet? Or if she is to be convicted, are you surprised that she already lost that license?
No, I'm not. She is, first of all, the most important part is she's presumed innocent of the charges that she and everyone is entitled to. When you have licensing boards of professionals, every state operates a little bit differently. Some states will suspend, some states will keep people on the job, others will suspend with pay, others will yank licenses and suspend without pay. South Carolina is apparently a suspend without pay state under whatever collective bargaining agreement the teachers have. And I don't think too many people are going to be upset about that.
And in South Carolina, I'm curious to know your thoughts on the charges specifically, like why criminal sexual conduct with a minor in the second degree as opposed to rape or statutory rape?
Well, that is basically statutory rape.
Mm.
Under the South Carolina Code, our scheme has three different levels of criminal sexual conduct based on what body parts were involved. That goes back to common law origins. So that is essentially statutory rape.
And in terms of just Callahan and the treatment that she's been receiving, her case has been kind of making a lot of headlines. But does any part of you think that she's being treated differently in terms of the criminal process, especially since she's out of jail right now?
I don't think so. First, she's presumed innocent. Second, I believe she's 33 or 34 years old with no prior record, to my knowledge. She's been a contributing member of society, doing a lot of good for a lot of students, separate from this one allegation. And this one allegation, which is in two different judicial circuits, so she'll have to deal with bond in both places. But these allegations are of a consensual nature. The law says someone underage cannot consent, but that's different than the use of force to accomplish a goal. So you have an underage person who participated. There's criminal exposure for Ms. Callahan if she ultimately is convicted of the charges. But I think at this point it is appropriate for her to be out on bond so she can review the discovery, work with her lawyers, do if treatment is appropriate for her, and it may very well be, go to treatment and do other things that can help her put her life and her case in a better position.
And in South Carolina, we've seen in other cases where it's pretty common maybe that a defendant faces charges in maybe multiple states, multiple counties. But in this particular case, we kind of have that same scenario with Nicole Callahan facing charges in multiple counties or jurisdictions. Talk to me a little bit about how that works. Do you see that pretty often in South Carolina?
I think you see that pretty often everywhere. I have a number of cases now where people are charged at one of the counties in the state, and then they have similar charges in another state. So you have to deal with who is going to take priority in the case. You have to deal with bond in both places, merging the bond conditions, and try to make it so that everyone is is somewhat satisfied with how the case is going to ramble forward. In this circumstance, it's, I think, Anderson County and Greenville County. They're neighboring judicial circuits. I would think that those two judicial circuits, the prosecutors would have a lot of interaction with each other, and they should be able to figure out which case will proceed first. If a guilty plea were to be arranged, likely those would all be dealt with in one hearing. So whichever county, let's assume Greenville County takes a lead, Anderson County would be part of the conversation about a plea offers. And if that's accepted, then they would send their paperwork to Greenville, and it could all happen in Greenville or vice versa.
And how difficult does that make it for a criminal defense attorney in order to defend their client if they're seeing it in multiple jurisdictions?
Well, it does complicate matters, but here this is the same employment, same alleged victim, same client. So it's a matter of geography. So I think the defense lawyer doesn't get to choose which district it would go first in. They might like working with one prosecutor better than the other prosecutor, and you don't get to make the choice. So you're playing the hand that's dealt to you on that circumstance. But if you're talking about going to trial, if you're rejecting the plea offer and wanting to have your innocence evaluated by a jury, it's very challenging because you may have to deal with other bad acts evidence from the other district coming into your case. And then if you win the trial, you have to go try it in the other county too. So it really, I think most people would think that would trigger some sort of double jeopardy issue.
Yeah.
The courts do not view it that way. That's one of the things where the law and sort of public understanding don't mesh.
Right, exactly. And I think what also makes this case a little bit unique is that we're seeing the victim really kind of speaking out, especially to the media, coming forward and talking about this case, something that we don't see very often in other cases. What are your thoughts about the victim speaking out now that the victim is 18 years old?
Well, we live in a world where people are speaking out on multiple social media platforms all the time. If he were my son, I would encourage him not to speak out and to keep as low a profile as possible under the circumstance, but that's a personal decision. And oftentimes people want to speak out either in situations like this, sometimes in defense of the person who's charged, and sometimes in support of the prosecution.
Yeah,
So
and
these are challenging situations.
Yeah, and it seems like from
And
this
it's challenging for the
standpoint.
prosecutor.
Right. And how
I'm sorry,
come that is?
Go ahead.
Oh, no, I was going to ask you
Well, I
how
think
come
it's
that is.
difficult for the prosecutor. I think it's difficult for the prosecutor standpoint because they don't have control then of the narrative. If a witness is saying something or a alleged victim is saying something that over discloses or inappropriately discloses or prejudices the defense in a way where you would have to continue the trial longer, it can create complications for the prosecution.
Does it create any complications for the defense too, in terms of maybe impacting their defense strategy too?
It could very much harm the defense. It could inflame the passions of potential jurors and make it difficult for somebody to get a fair trial. I think that would be the biggest concern for me if I were defending Ms. Callahan.
Question to you, Chris, is do you see this case actually going to trial? You know, we've seen multiple times where cases go on and on and on, then jury selection begins, and all of a sudden there's a plea deal. Do you think you can see that possibly happening in this case, or do you see a strong possibility it will actually go through a trial?
Well, so in the vast majority of cases are resolved either by dismissals or pleas, and that's criticized by a lot of people, but there's a reason for it. And in South Carolina, we're an underfunded state. We have too few judges and a lot of courtrooms. So the only way to deal with the dockets are for most of the cases to be resolved by plea bargaining. That said, in this circumstance, without ever having spoken to Ms. Callahan or her counsel, if she's making public statements about being pregnant with the young man's child, then it seems like this would be headed for some sort of plea. I don't know how you go to trial in a statutory rape case, a criminal sexual conduct case with somebody underage, if you're carrying DNA evidence that would establish your guilt of the case. So it sounds like it would be a matter of sentencing, that this would be a sentencing case, and that's why being out on bond and getting whatever treatment and intervention is appropriate could be very helpful for her.
And I guess we'll see how this all continues to unfold. Chris, I want to thank you so much for your time and your insight into this case. Before we sign you off, though, is there anything else you'd like to add?
No, that's it. Thank you so much. I appreciate it.
All right. Again, Chris Adams, thank you so much for your time. I really appreciate it, too. Today, the case is still unfolding. Multiple counties are pursuing charges. Prosecutors say that the pattern of alleged grooming is clear. As for Callahan, she's out on bond, pregnant, and awaiting trial on those long lists of charges. The South Carolina State Board of Education says that her suspension will remain in effect until due process is held or the matter is otherwise resolved. Well, that does it for this episode of Sidebar. If you want to see more episodes, head over to the Law&Crime YouTube page or subscribe to us anywhere you get your podcasts, whether it's Apple Podcasts, Spotify, or YouTube. I'm Elizabeth Millner in for Jesse Weber, and this has been Sidebar presented by Law&Crime.